It's your money, and you can leave it to your non-human family members if you want to. I'm Todd Marquardt, attorney for Marquardt Law Firm. We focus on business law, last wills, living trusts, and tax-protected inheritance plans. Section 112.037 of the Texas Trust Code states that a trust may be created to provide for the care of an animal, also known as fur babies and non-human family members. Be careful that you comply with the rule against perpetuities, or it will be invalid and unenforceable. This brings up an important point. This type of trust is more difficult to correctly create than you might think. Many people have screwed it up, like in Hahn versus Stange, in which the trust maker's pet trust failed because the trust maker's cats could not be identified or found after her death. And Brewer versus Fountain, where two charities were named in addition to the pet trust, and there had to be a trial to determine whether there were inconsistencies between the original will and the codicil to a will. Do you remember the Queen of Mean, the famous hotelier and convicted tax evader, Leona Helmsley? She had a trust fund valued at over $12 million that she left to her dog named Trouble. The court found that the trust was incorrectly prepared and decided that only $2 million would be used to care for Trouble, and the other $10 million went to Helmsley's grandchildren, who she clearly wanted to disinherit. The Humane Society estimates that over 500,000 pets per year must be sheltered because of a deceased or incapacitated owner. Do-it-yourself plans often backfire. What if a proposed caregiver has an allergy, injury, financial problem, or uncooperative spouse and can't care for your pet? You have made the decision to leave your assets to your loved one. Doesn't it make sense to hire a professional to prepare correctly?